Thank you, Mr. Chairman. I want to start by saying that I did pay very close attention earlier when some of our colleagues spoke very passionately about their desire to eliminate domestic violence and do our best to stomp out such a scourge on our society. And I am completely, utterly with them in every respect. My concern really is about how we go about that process. And simply, I'm going to object and vote against this particular proposal before us, just simply because I think it's a bad bill. I don't think it accomplishes its stated goal, and I believe it's misguided on many different levels. And I think part of it stems from a refusal to acknowledge that firearms are simply tools. They are inanimate objects, and that they are very often, and possibly far more often, used defensively than offensively. What makes this bill extremely ironic to me is that it intends to reduce domestic violence, when I think there is a very distinct possibility in some cases it's likely to exacerbate it. So let me just reiterate what the chairman explained as what's happening in this legislation. There's a lot going on, and I want to talk at some length about the various different pieces and moving parts here. But the major objection that most people have, including myself who are opposed to it, is the concept of due process. What's happening here in this bill is we would be changing the law in a way that says that someone who is the recipient of an ex parte temporary restraining order would have to surrender their firearms within 24 hours. And more importantly, they would have to do that without an opportunity to be heard in court beforehand. Under current law, a person who is a subject of an ex parte restraining order would be granted a hearing at the 14-day mark to be able to explain to the judge why or why not they should be able to retain their firearms or whether the restraining order should go forward. I think it's worth noting that the law exists the way it does for a reason. I'm quite certain that way back when this law was originally passed, the reason why the 14 days was there and the reason why the firearms were not taken until after the hearing was precisely because of the constitutional requirement for due process. The fact that this committee wants to undo that now, it utterly shocks me. Due process is, simply put, the clause that guarantees us our American concept, one that we all cherish and love, that we were brought up on, that someone is innocent until proven guilty, that you should have an opportunity to present a defense, you should be able to face your accuser before being punished for a crime. This is one of the things that our forefathers fought for when they created our Bill of our new country and ultimately the government that we have and the rules that guide us in the Bill of Rights. It's not something that I think we should take lightly and without some significant thought beforehand. This bill, if it passes, will simply deny the constitutional rights of anyone unlucky enough to find him or herself on the receiving end of an ex parte TRO, legitimately or not. And I fully understand the argument that the proponents make that we must weigh public safety versus the constitutional protections that we have for our individual liberties. My concern is that in many cases, the TRO may cause an erroneous deprivation of those rights. I've got a little chart in front of me. It's from 2014, but it's a graph that shows me how many ex parte restraining orders were applied for and granted, and how many of them became full permanent restraining orders. And I won't bore you with the numbers, but it's about half. And what this says to me is that at least in some cases, even if it's one, that some of these TROs were unnecessary. Of course, you could sit down and analyze every application for a TRO and determine whether or not it's valid and whether there is legitimate due process. But I would say that the more substantial the private interest that's affected, the more likely it is that the TRO does not satisfy due process. At the public hearing, the majority of those who that testified did so in opposition, and because they object to the lack of due process that would be afforded to citizens, precisely because they are gun owners who could be subjects. I think more important than anything is what we are trying to do is ascribe a criminal remedy and a civil process. As was stated during some of the earlier conversation, there is existing law that does provide for a mechanism for someone who is in fear of a domestic abuser to have that person detained and have their firearms confiscated. I'm going to get to that in just a second, but I want to just hit on a newspaper article that I brought up during the public hearing. And granted, this is from 2010, but between you and me, I didn't take any time to go through and research what restraining orders are out there and what reasons they've been granted for, but I just grabbed this simple Google search CT Post article from 2010, and it cites several instances where temporary restraining orders were granted on an ex parte basis. And I found it shocking. I mean, I literally almost fell out of my chair when I read these. The first one says, a Bridgeport man recently applied for a TRO to prevent his future in-laws from coming to his wedding with their daughter. A Monroe man applied for a restraining order claiming his wife and mother-in-law were poisoning his contact lens solution. There was another one where a man came and claimed that his neighbor's dog was speaking to him in tongues. So just to put those out there and put that in perspective, that someone may have their fundamental constitutional right to defend themselves, and this could be a male or a female, and it could be someone who wishes to defend themselves as a female from a male abuser, could have their rights taken away simply because someone makes a one-sided claim that that person never gets to answer to, never gets to defend themselves against. This is our concern. It's a legitimate one. It's the reason why there was so much passion on this side of the aisle about the last bill and the amendment that was before us. It's because we care about domestic abuse. What we don't want to see happen is people's rights be trampled in the process. So, like we said, only about half of the TROs become permanent. So that says that there's got to be some cases where there was insufficient merit to grant the TRO to begin with. And what about the judges? Are we putting judges in a very, very awkward predicament? So if I'm a judge and someone presents a affidavit to me asking for an ex parte restraining order, claiming that someone's afraid of another person, whether I believe that claim or not, doesn't it make sense for me to grant it in virtually every case purely to protect my own interests, that I didn't screw up and not take someone's firearms away from them? God forbid something doesn't happen. I know that some other speakers are going to follow up, and they are going to go into great detail about the possibility that is a genuine and real one, that someone who is an abuser could use this law, if passed, to actually disarm the person that they want to victimize. There is a reason why we have civil processes for restraining orders, and we also have the risk warrant statute in our current law. And it's because these are two entirely different situations. And I want to try and break this down into just a way that people can understand. I am certainly sympathetic to those folks who would say that the reason why they do not want to go to the police is because they are fearful that if they do that, somehow the person that is abusing them is going to become enraged and there is a greater potential for violence. But let's ask ourselves, under the TRO law, if passed, what's going to happen is that person's going to go to court and they're going to fill out an ex parte affidavit, which is going to go to a judge, and if granted, the judge is going to authorize the risk warrant to, or rather the restraining order to be issued, and a marshal is going to be charged with delivering that, he will automatically contact a police officer if there are guns involved, per the language before us. So here you have the police involved right there. That's the first thing I would say. And the second thing is, when does this happen? If I'm honestly scared, if I am someone who has been threatened by, another person that I have been in a relationship with or something like that, and I'm genuinely scared for my life, I am not waiting until Monday morning at 9 o'clock to go to court and fill out a restraining order. I am going to call a cop, because that's what you do. And the police come, and they have an actual mechanism called the risk warrant statute. And the reason why those of us who object to the restraining order being used to take someone's firearms in a one-sided circumstance is satisfied with the risk warrant, because the police will actually do an investigation. It might be no more than a couple of questions, but it will satisfy the requirement that they have probable cause to believe something is going to occur. That does not exist on the risk warrant side. And there is no fact-checking, there is nothing other than a one-sided document in the case of the TRO before you deprive someone of their rights. I could point out that if you get arrested for domestic violence, if you actually go and attack someone and beat them up and the police come and arrest you, someone can correct me if I'm wrong, but I believe that you have 48 hours to surrender your firearms. And that's a case where we know something has happened. Finally, I just want to point out one final thing about this legislation, is that it's not going to work anyway. And for that, I have another newspaper article. My Google skills, Mr. Chairman, are improving every day that I serve in the legislature. This is from the New Haven Register from March 10th this year, just a couple weeks ago. And it's about a guy, a West Haven man, who was arrested Wednesday night after police say he assaulted and choked a woman and then tried to hit her with a boulder outside a city apartment. It's really interesting because I read on through this article, and it turns out that this man who used a boulder to attack and abuse someone, also, when the police arrived, it turns out that he had 2 illegal firearms, one with the serial number obliterated, and another one that actually had 15 rounds in it, because I'm sure he was paying attention to that law, as most criminals do. And he also had been the subject of a protective order that protects that woman. So let me ask you guys, I mean, if we pass this legislation, can you see this same situation occurring? Do we think that somehow, some way, passing a law is going to actually eliminate the chance that someone can do violence against someone? It certainly will not. So before we pass this, we should try and find out what the proper remedy is. And I believe that the proper remedy is the current law, which is that a temporary restraining order is for a civil purpose, to keep people separated on the level that it does. And when there are actual circumstances that there is impending possibility of violence, you use the risk warrant statute, you involve the police. I urge my colleagues to vote against this bill, and you will have the opportunity to vote for a much better bill in a few minutes, I hope. Thank you, Mr. Chairman.